Today, we are diving into the world of arbitration clauses. If you've ever wondered what an arbitration clause is and why it is important, you're just in the right place. Whether you're a business owner, a lawyer, a law student, or someone who's just curious about the legal side of things, we've got you covered. In this video today, I will be explaining how you can draft an effective arbitration clause. Now, you must be wondering why it is important for us to discuss this. Well, drafting an effective arbitration clause is the most essential part of any arbitration, as sometimes, due to badly drafted arbitration clauses, your dispute may end up being outside the scope of arbitration itself, and you may be thrown out into a jurisdictional court which you have no idea of. But question is, why should you opt for arbitration in the first place? Well, let me tell you the pros. Arbitration is usually less formal in nature. Arbitration is also faster than going to court, and it is not expensive. The cost of arbitration can actually be lower than going to court, especially if the dispute is complex and it would require extensive court time. Coming to the Act now. What does the Arbitration and Conciliation Act say about drafting a clause? Let me tell you. So, Section 7 of the Arbitration and Conciliation Act says that the parties may refer all or even certain disputes to arbitration, and arbitration can also be in the form of a clause or in form of a separate agreement altogether. And the most important thing is that it should be in writing. Now, for you to be able to draft an effective clause, you should know the essentials which should definitely be present in your clause to make it effective. Let us understand them one by one. So, the first thing that you need to focus on is the scope of the agreement. Ideally, widest possible scope should be defined. One of the main reasons as to why awards are set aside is because the matter itself is outside of the scope of arbitration. Now, you may say that why don't you show us how you should draft it? So, let's do one by one and I will show you in parts how you can do it. Let's check out how the clause of scope should look like. While defining scope, you should use this language. Any disputes or difference arising from or in connection with this contract, including the adjudication of its validity, termination, or breach of contract, shall be referred to and resolved by arbitration. That's number one. The second thing to focus on is the governing law and jurisdiction. Keep in mind that the seat is the center of gravity of arbitration. Seat basically decides the jurisdiction of the court. You basically allow laws of that jurisdiction to follow you. Whether you choose France, Germany, or even India, the law will follow you there. What is the consequence of not mentioning the seat of arbitration? You may end up in a court or a jurisdiction that you know nothing about. And you would usually find parties negotiating about the seat of arbitration mostly. Another term that has been coined by the courts is the venue of arbitration. Now, venue simply decides where the parties would sit and arbitrate. It could be Kolkata, Ahmedabad, or anywhere in the country. Now, how do you write that clause? Let me show you. The governing law and jurisdiction clause looks like this. The seat and the venue of arbitration shall be so and so. You can decide whether it has to be Bombay, Bangalore, Delhi, or whatever you like. And the proceedings shall be governed by the laws of India. Now, once you have mentioned the scope, seat, and venue, and the governing law, the next thing that you need to consider is whether you want an ad hoc arbitration or an institutional arbitration. Let's discuss them. Ad hoc arbitration is where the parties determine the rules of arbitration themselves. In this procedure, the parties can decide the procedure on submission of statement of claims, the manner in which they will submit evidence, and other aspects of the matter. These are, of course, subject to the Arbitration and Conciliation Act and the laws of India. Let's discuss institutional arbitration. Now, this is where the parties may choose to follow the rules of a specific institution, and the entire arbitration in that case is regulated by the institution itself. Bombay Center for International Arbitration is one example. Now, the arbitrator, the fees, in fact, the procedure is all decided by the tribunals. How can you write this in your sample clause? Let me show you. You can simply write the party shall follow the institutional rules of, let's say, the Mumbai Center for International Arbitration, and you can put that up here. As simple as that. Another thing to specify is the language of arbitration. Now, assume if one party is in Kolkata and other is in Bombay. The proceedings, if initiated in Bombay, could be carried out in Marathi and would land the other party in trouble. Therefore, you need to be very specific about which language you need to choose. How can you write this in your sample clause? Let me show you. It's a very simple line. It says the arbitral proceedings shall be conducted in English. You can choose whichever language is convenient to your clients. Another thing to focus on while drafting this clause is the number of arbitrators. You could either mention that the parties will refer it to a sole arbitrator or refer it to the panel of odd number of arbitrators. How do you write this? This is how you can write it. The arbitration shall be conducted by a sole arbitrator. In this case, we've chosen a sole arbitrator who shall be mutually decided by the party. Now, other important aspects that should be present in a clause are the qualifications of the arbitrator. In this situation, if there is a dispute, let's say about a quality or a quantity or a technical dispute, you can have someone specialized in the industry and specify that the arbitrator shall at least be an engineer or an architect or a lawyer or somebody who has knowledge in that particular field. Any other person would not be able to do justice to your case. You can also include the fees of the arbitrator. Institutional courts or appointed arbitrators may have specified fees. However, in ad hoc arbitrations, you can set a fee cap that needs to be paid to the arbitrator. And lastly, you can also tell about the time limit for appointment of arbitrator. Section 21 of the Arbitration and Conciliation Act says that after the notice of arbitration, the party needs to respond within 30 days. You're free to change this if you wish to once you mention it in the clause. Once you include all of the factors that we have just discussed, there you have it, one effective arbitration clause. Let me show you how the complete clause looks like by way of an example. Consider this situation. Peak Suppliers Private Limited is having its registered office at Mumbai and it's going to supply 100 tons of cement to ABC Construction Private Limited, which has its registered office at Delhi every month. They have entered into a material supply agreement for this purpose, and this is for supply of cement. They choose arbitration as the alternate dispute resolution mechanism. Now, if you are required to formulate a clause for these parties, how would it look like? This is how. Any disputes or differences arising from or in connection with this contract shall be referred to and resolved by the sole arbitrator. The seat and venue of the arbitration shall be, you can say, Bombay, and the courts of Bombay will have exclusive jurisdiction. The arbitral proceedings shall be conducted in English, and the award shall be final and binding on both the parties. There you have it, an effective arbitration clause, including all the essential elements that we just discussed. I hope you like it. Let me know in the comments if this helps you and share it. Share it with a lawyer, share it with a friend who wants to draft or is struggling to draft an arbitration clause. Let me know in the comments how it went for you and if you want more such videos. See you in the next video.